I'm Matthew Huggett, Employment Partner at Carbon Law Partners. I'm here today to provide an update on the latest regarding furlough and the government's job retention scheme. So last week saw the 7th new version of the guidance that's been published by the government, following the original announcement of the scheme on the 20th of March. So guidance was first issued on the 26th of March, and this now sees the 7th new version of the guidance in the past 5 weeks, with the latest briefing on the 23rd of April. There was also an announcement by the government on Friday the 24th of April in relation to payment of family leave, which I'll turn to very shortly. So, what's happened in the past week or so in terms of the formal guidance, and how does this actually affect employers? So let's have a look at some of the main points. Annual leave can now be taken during furlough. This was actually finally confirmed in the guidance published on the 17th of April. It stated that employees and workers can take annual leave during furlough, and this reflects the position that was set out in ACAS guidance that was set out at a much earlier stage. This had been previously unclear for some weeks and caused a great deal of uncertainty about the treatment of the Easter bank holiday in particular. And there was great concern regarding this because, of course, employers didn't want annual leave to break the continuous 3-week period that was required in order to have a qualifying claim under the scheme. So it is of much relief that this has now finally been clarified. But there's one point that isn't absolutely certain, and that's whether employers can actually require employees to take holiday. Now, the reason that this isn't absolutely clear is because the guidance in relation to the taking of holiday during furlough is actually set out in the employee's guidance rather than the employer's guidance. One view is that because this is in the employee's guidance and not the employer's guidance, then employees can request to take the holiday, but employers cannot require employees or force employees to take it. But this is probably splitting hairs, and it's almost certainly okay for employers to categorise certain days as holiday, as long, of course, as they're doing so in accordance with the contract of employment or alternatively the requirements under the working time regulations. And of course, requiring employees to take holiday may prove somewhat unpopular whilst they're on furlough, as quite clearly they're not going to be able to go to the beach or use their holiday in a way that they would normally do so. So if you are requiring employees to take holiday over and above the public holiday requirements, you do need to have a little bit of a think about the knock-on consequences for an employee relations point of view. Now, turning to family leave. So this is the announcement that was made on Friday the 24th of April. So furloughed workers planning to take a period of family leave, so maternity leave, parental leave or adoption leave, any form of paid family leave, they will now be entitled to receive payment for that family leave based upon their usual earnings rather than based upon their furlough rate of pay. This therefore avoids the problem that could have otherwise transpired because, of course, in order to take family leave, when you take your family leave, the calculation in relation to the payment is based upon your previous 8 weeks' earnings. And if your previous 8 weeks' earnings has been at the 80% of furlough pay, then of course you could have then been financially disadvantaged if this amendment had not been made. So this is a much welcome amendment in relation to anyone planning to take that leave. Returning to the point about when employees are eligible, and particularly this is about the qualifying date, which of course was originally the 28th of February. So employees and workers had to be employed or engaged by that company and be on their payroll on the 28th of February in order to be able to qualify for the scheme. But there was then a reasonable amount of criticism about those affected who had changed jobs in between the 28th of February and the announcement of the scheme on the 20th of March. And so in response to that, the government then, as a welcome response, changed the date from the 28th of February to the 19th of March. But unfortunately, for most monthly paid employees at least, the RTI submission also needs to have been done by the 19th of March. So if anyone's going to be getting paid on a monthly basis after the 19th of March, even though they might have started work before then, started to be employed before then, they then wouldn't be eligible still under the scheme. Now, there is a table within the guidance that sets out some more detail in relation to the dates of eligibility. So please go to the website, go to the guidance and have a look at that table, because it can help take you through this rather complicated eligibility issue. This is quite a straightforward point actually. It's just in relation to fixed term employees and fixed term workers. If their contract had expired between the 28th of February and the 19th of March, then they can also be rehired and furloughed in the same way that any other employee that perhaps had left their employment, they can also be rehired and furloughed. And of course, you can continue to renew fixed term contracts and furlough those workers as before. There is also, on the government's website, there is a new furlough calculator that's available. Please follow the link, or of course just Google the keywords out of that, and that will take you straight to that calculator. And then the final point that I want to make is in relation to notice pay. And this is notice pay whilst on furlough. And there is some discussion about whether you can issue notice of, or if you do issue notice of termination whilst during a period of furlough. For example, if you're issuing notice in relation to redundancy, which is then intended to expire at the end of June, but then if you do so, whether you actually have to pay a full period of notice pay during that time, or whether in fact the employee continues to receive their 80% furlough pay during that notice period. This isn't clear, and there are some different views amongst commentators on this point at the moment, but what I would say on this is that if you do have an employee with post-termination restrictions in place, that you want those post-termination restrictions to continue to be enforceable, it would be prudent for you to eliminate the risk of any breach of contract by paying the notice pay in full. Because if you don't do so, and if the argument then does fall against you, and you are required to make the payment in full and you haven't done so, the contract will have been breached and those restrictive covenants won't be enforceable. But if you don't have important post-termination restrictions, then of course you might just simply want to take a business risk approach. Do get in touch if you need any further help and advice. Of course, this video is only intended to give an update on the guidance provided by the government and doesn't constitute any legal advice. So if you do need some legal advice, then please either contact us or of course one of your normal advisors. And if you do want to receive any regular updates from us, then please send me an email and to be added to our mailing list, and subscribe to our channel for further video updates, or of course follow me on LinkedIn or Twitter. Thank you for your time.